a state came up with a law that said so long as a notary, that's official, that's recognized, certified that you cast your ballot on Election Day and it was delivered later by whatever means, common carrier or not, what in your theory of the preemptive effect of this statute would preclude that law?
I think 2 points on that, Justice Gorsuch. One, I think, is that
pick your best.
Well, I think one's kind of a point in our favor and one's kind of a point against our friends, which is that there's a finality of submitting it to an official. And
it's been notarized by, well, how about a justice of the United States Supreme Court? Is that official enough for you?
I mean, it's pretty official. I don't think it's been submitted.
That's pretty official.
It's pretty good, Your Honor, but I don't think it kind of hits submission to the state.
Okay. Well, I wanted to explore. So that's not submitted to the state, even if it's notarized, an affidavit. It was final on the day of, and somebody brings it into the state offices a week or 3 months later. That doesn't count. But if it goes into the mail, it does. What in the statute? What words in the statute would you have us read that rule into?
Well, I mean, I think, just to make sure I understand, I think that's fine under my friend's view, too, Your Honor. I mean, a notary could be...
I'm asking about your view, counsel.
Sure. So I think...
You're saying that's not fine, and I want to understand what in the federal law preempts that.
Well, I think, number one, I just am not, at least as I'm understanding the hypothetical, it doesn't appear to be submission to the state, Your Honor.
It gets submitted to the state 3 weeks later, just not by common carrier.
Well, if what you're saying, Your Honor, is that a notary has been deemed a sufficient ballot receiver under state law, then
yes.
I think...
Then that's okay, too. Okay, what if state law... So now you're saying that is okay.
I think it may depend on how... what the level of officiality
is.
Well,
the state says it's official, by God. When a Supreme Court justice or perhaps just a notary says it's official, that's good enough under your... It has to be, I think. And if that's okay, why can't a state say, how about a time-stamped video showing that I voted on Election Day? Here I am filling out my ballot, and then my brother or maybe some aggregator of ballots brings it in a week or 3 later. And that's got to be okay, too, doesn't it?
I think it's still just – I keep coming back, Justice Gorsuch, to this pedigree of submitting it to a state. I mean, I think as a good example –
Well, the state says that's official. State says that's fine. Ballot aggregators are great. And so long as it's a time-stamped video or a notary or maybe a Supreme Court or who knows what, the librarian says you cast it on the day of the election, then we're good to go, right?
I mean, I do still have some concern that it has not been submitted.
Counsel, why are you fighting the premise? In the Civil War, at least 2 states permitted military officers who weren't sworn state officials. They were federal officials, but not sworn state officials, to accept the ballots and transmit it by mail to the state, okay? And that was in the Civil War, all right? Since 1918, we've had laws like Mississippi. By 1944, 8 of them. Since then, 12 more by 1886. And now half the states permit absentee ballots that are dropped in the mail, correct? No different than in the Civil War. We have no federal law that says that's not okay, for the state to designate someone by whom an official ballot has to be given by Election Day, correct? And if the state wants to make it a notary republic, if it wants to make it a military officer, if it wants to make it a Supreme Court justice, if it wants to make it anyone, as long as it's done by Election Day, that's what counts, correct?
I mean, I think that's possible. We're not quite asking for that, Your Honor. I really don't.
No, you don't, because you're only defending this law, and this law is very consistent with what happened in the Civil War. It's very consistent with what has happened for over 100 years. There's nothing in federal law that has prohibited it explicitly, correct?
That's right, Your Honor.
Well, right. Justice Sotomayor is asking you what I think she intends to be a friendly question, but maybe you want to think about whether you want to go that far. What if the state designates an official of the Republican Party or the Democratic Party who receives these ballots, collects ballots, and fills out an affidavit saying, I received all these and I will faithfully deliver them, would that be okay?
Well, I think it's actually okay under my friend's view, Your Honor. We're not making that ask. I mean, as far as my friend's view are concerned, so long as somebody's designated a ballot receiver, they can be fine. Party boss, party bagman, relative, any of those, so long as the state says you are a ballot receiver, that's fine. The only thing that apparently is not fine is U.S. Postal Service common carrier. And I think that is, a very odd way to read those statutes.
Well, the Postal Service is not part of the state, and a common carrier isn't part of any government.
That's right, Your Honor. But I mean, certainly we all know the status of the U.S. Postal Service as a highly regulated government entity with certain obligations. Common carriers, in a very similar way, highly regulated with similar obligations. And they give, in both cases, they're imbued with a duty to deliver what they received. And in fact, a duty that's, I think, maybe a good example is the fact that the IRS accepts tax returns, which are obviously highly consequential documents with key timeliness requirements. The IRS accepts tax returns both through the mail and through common carriers.
Well, you will accept ballots that are received within 5 days after Election Day. The date that's set as Election Day, right?
That's right, Your Honor.
And you have a variety of line drawing problems. So we've been exploring one. To whom and by what means is the ballot to be delivered to the state? But what about the length of time that a state could choose? Isn't it the case that some state allows, will count ballots that are received 21 days after Election Day?
There are a couple that at the outlier it's kind of canvassing and it can go that far. I think more common is about
Is that okay? Is that all right?
As far as the federal election day statutes are concerned, yes, Your Honor. And I think this actually gets to a good point that loops back to something Justice Gorsuch was getting at in a certain way, which I think he was saying, what in the federal election day statutes decides that? I think that's the key point in our favor. This is an area where states get to go first, make these decisions. Congress can step in, but the idea.
So there's no limit, except I suppose the day when the presidential electors have to be appointed, or the day when the next Congress starts its session. That's the only limit on counting mail-in ballots.
Those are some of the limits, Your Honor. But I'd also say that the federal election day statutes don't require states to count ballots at all. It doesn't speak to counting, period. So, I mean, if a state really didn't want
not counting, but being delivered. So I do think it is a consequence, and you can tell me if I'm wrong, but just so we can wrap this up, that by any means and by any date up until the next Congress meets, a state can receive ballots.
I think for congressional races, potentially, yes, Your Honor. I think there are other Title III kind of things that push action earlier in the presidential context.